I'm Clarice Warner, the girl with the pearls, the founder and senior education director of the Professional Reimbursement Network, LLC, where coding education is key. Today, we are talking about the compliance guidance that just came out. OIG is tightening up those reins and dropped just the other day a whole compliance guide, 76 pages of compliance guide. We are going to hit some of the highlights and some of the things that we've already talked about. They have kind of reinforced. So we're going to take a look at that. Here we are here on the OIG's website. Here's the compliance guidance or compliance program guidance. They got a whole web page here. You can download the complete guidance, or you can go to the individual sections that talks about all of the different things related to this document. Today, I just want to talk about the healthcare fraud enforcement and other standards, the overview of certain federal law sections. So that's in section 2. So let's jump over here and see what we got. This guidance does not create any new laws or legal obligation, and the discussions in this guidance are not intended to present detailed or comprehensive summaries or lawful or unlawful activity. They ain't telling on nobody, but they telling. It all begins with kind of giving you an overview of the history. They also want to let you know that it does not address state fraud and abuse laws. Let's talk a little bit about them. First, we got the federal anti-kickback statute. And this is where it prohibits entities involved in federal healthcare program business from engaging in some practices that are common in other business sectors, such as offering or receiving gifts to reward past or future referrals. As a general matter, the federal anti-kickback statute is an intent-based criminal statute that prohibits remuneration, whether monetary, in kind, or in other forms, in exchange for referrals of healthcare program business. More specifically, under the federal anti-kickback statute, it is a criminal offense to knowingly and willfully offer, pay, solicit, or receive any remuneration to induce or in return for the referral of an individual to a person for the furnishing of or arranging for the furnishing of any item or service reimbursable under a federal health care program. The statute's prohibition also extends to remuneration to induce or in return for the purchasing, leasing, or ordering of, or arranging for or recommending the purchasing, leasing, or ordering of any good, facility, service, or item reimbursable by a federal healthcare program. The statute covers activity occurring directly or indirectly, as well as overtly or covertly in all instances. And then remuneration is anything of value, cash, in kind, or in any other form. They give some examples. It may not take the form of cash equivalents, cost sharing, waivers, or subsidies, an opportunity to earn a fee, items, space, equipment, and services, regardless of the amount of remuneration. You can do this for $10 and get all kinds of problems. Violation of the federal anti-kickback statute constitutes a felony punishable by a maximum fine of $100,000, imprisonment up to 10 years, or both. Conviction also will lead to mandatory exclusion from the federal health care programs, including Medicare and Medicaid. Liability under the federal anti-kickback statute is determined separately for each party involved. And in addition, they may be subject to False Claims Act liability and civil monetary penalties. So you see how you add on top of, it's like you build the foundation, you find out something wrong, well, woo, you done violated this too. So now you're subject to the penalties of those. Oh, wait, you done violated this too. And now you're subject to the penalties of those. So yeah, where you may think one thing, no, it's something else. Now there are some safe harbors and there are some things that under compliance that you can do that offsets. But it states real big, individuals and entities should evaluate their arrangements that implicate the statute and do not fit into a safe harbor by reviewing the totality of the facts and circumstances, including the intent of the parties. They said that this is intent. And then they give you some examples of some problematic arrangements. And then there's a FAQ. So some key questions that you may want to ask when you're putting together or when you're considering arrangements with others. Physician self-referral law. This is also known as the Stark Law. Prohibits a physician from making referrals for certain designated health services payable by Medicare to an entity with which the physician or an immediate family member has a financial relationship, unless an exception applies and its requirements are satisfied. Financial relationships include ownership and investment interests, as well as compensation arrangements. For example, if a physician invests in an imaging center to which the physician refers Medicare beneficiaries for designated health services, the PSL requires that the financial relationship satisfied all requirements of an applicable exception. If it does not, the PSL is physician start or self-referral law, prohibits the physician from making a referral for DHS to be furnished by the imaging center and prohibits the imaging center from billing Medicare or any individual, third-party payer, or other entity for the improperly referred DHS. Some of those services include laboratory services, physical therapy, occupational therapy, outpatient speech language pathology services, radiology, radiation, DME, parental and enteral nutrients, equipment and supplies, prosthetics, orthotics, prosthetic devices, home health services, outpatient prescription drugs, and inpatient and outpatient hospital services. Because CMS's regulation defines certain categories of DHS by CPT and HCPCS codes, CMS publishes an updated list of codes for the relevant DHS annually. Did y'all know that? All right. So here are some things that you need to determine whether certain key elements are present under the PSL. The PSL is implicated only when all 6 of the following elements are present. There's a physician, makes a referral for designated health services payable by Medicare to an entity with which the physician or an immediate family member or the physician organization in whose shoes the physician stands has a financial relationship, which could be a direct or indirect ownership or investment interest in the entity or a compensation arrangement with the entity. See, this is why healthcare lawyers get paid so much, because they got to do a whole bunch of work around this. And I had wonderful relationships with legal departments, and it was confusing everybody. And so there's always a lot of work in making sure that these deals are what they say they are, and that they're structured appropriately, making sure that none of these are violated. And so they also give you some examples that are likely to be prohibited. So Dr. X works in a physician practice located in a major city. Dr. X's sister owns a freestanding laboratory located in the same city. Dr. X refers all orders for clinical lab tests on Medicare patients to the sister's freestanding laboratory. That ain't right. What to do if you identify a problem? From a compliance perspective, it is important for entities that furnish DHS to have a method to keep track of and review closely their financial relationships with physicians who refer Medicare patients to them. CMS, which is the government agency charged with interpreting the PSL, has a CMS voluntary self-referral disclosure protocol that enables providers of services and suppliers to self-disclose actual or potential violations of the PSL before somebody blows the whistle. The big one, Cadillac of them all, the False Claims Act. The Civil False Claims Act provides a way for the government to recover money when an individual or entity knowingly submits or causes to be submitted false or fraudulent claims for payment to the government. The False Claims Act, among other things, prohibits knowingly presenting or causing to be presented to the federal government a false or fraudulent claim for payment or approval. knowingly making or using or causing to be made or used a false record or statement to have a false or fraudulent claim paid or approved by the government, and knowingly making or using or causing to be made or used a false record or statement to conceal, avoid, or decrease an obligation to pay or transmit money or property to the government. The False Claims Act defines knowing and knowingly to mean that a person with respect to information has actual knowledge of the information, acts in deliberate ignorance of the truth or falsity of the information, or acts in reckless disregard of the truth or falsity of the information, and no proof of specific intent to defraud is required. In short, the False Claims Act defines knowing and knowingly to include not only actual knowledge, but also instances in which the person acted in deliberate ignorance or reckless disregard of the truth or falsity of the information. This means individuals and entities cannot avoid liability by deliberately ignoring inaccuracies in their claims. Filing false claims may result in liability of up to 3 times the program's loss, plus an additional penalty per claim filed. So that's why those numbers usually are inflated, because they don't look at just one claim. They're looking at hundreds of claims. So multiply that by 3 times, plus the additional penalty per claim. So that's why you see these huge, large numbers. A claim that is tainted by illegal remuneration under the federal anti-kickback statute or submitted in violation of the PSL is also false or fraudulent, creating liability under the Civil False Claims Act. Further, the False Claims Act contains a whistleblower provision that allows a private individual to file a lawsuit on behalf of the United States, and if appropriate, entitles that whistleblower to a percentage of the recoveries. Anyone with knowledge or potential fraud can be a whistleblower, including current or ex-business partners, hospital or office staff, patients, or competitors. There is also a Criminal False Claims Act, and criminal penalties for submitting false claims include imprisonment and criminal fines. If an entity identifies billing mistakes or other non-compliance with program rules leading to an overpayment, the entity must repay the overpayments to Medicare and Medicaid to avoid false claim liability. So that's false claims. You can also go out to the actual False Claims Act that lists all of it. It tells you specifically what those penalties are. I don't think they've said it in here, because oftentimes they will go back and raise that penalty. So the additional penalty for each claim filed, up to $21,000 for each claim, plus 3 times the amount of the overage. All right, civil monetary penalties. The OIG is authorized to pursue monetary penalties and exclusions through a variety of civil authorities, most notably the Civil Monetary Penalties Law, or CMPL. So under CMPL, the OIG can pursue assessments in lieu of damages, CMPs, and exclusion from participation in the federal healthcare program. So with this authority, the OIG can address a wide variety of improper conduct related to federal healthcare programs and other HHS programs. The CMPL principally addresses fraudulent and abusive conduct. In addition to the OIG CMP authorities that closely parallel the False Claims Act, the OIG has additional CMP authorities aimed at certain specific types of conduct unique to HHS and the federal healthcare programs. For example, the patient dumping CMP. While False Claims Act cases are pursued by the DOJ on behalf of HHS in federal court, CMP cases are administrative and pursued by the OIG before an HHS administrative law judge. So you in court on all kinds of stuff if you're doing something that you have no business doing. So by statute, different categories of conduct result in different penalty amounts. For example, false claims result in penalties of up to $20,000 or per item or service falsely claimed, and improper kickback conduct results in penalties of up to $100,000 per violation. Here's some things that could lead to CMP liability. Presenting a claim that a person knows or should have known is for an item or service that was not provided as claimed or is false or fraudulent. Oh, we talked about this recently. Arranging for or contracting by employment or otherwise with an individual or entity that the person knows or should know is excluded from participation in a federal healthcare program for the purpose of providing items and services for which payment may be made by a federal healthcare program. Presenting a claim for a pattern of medical or other items or services that a person knows or should know are not medically necessary. Committing acts described in the federal anti-kickback statute. Failing to report or return a known overpayment. Failing to provide an adequate medical screening examination for patients who present to a hospital emergency department with an emergency medical condition or in labor, that's EMTALA. Making a false record or statement material to a false or fraudulent claim for payment for items and services furnished under a federal health care program. Transfers remuneration to a Medicare or state health care program that the person knows or should have known is likely to influence the beneficiary's selection of a particular provider, practitioner, or supplier for the order or receipt of any item or service for which payment may be made in whole or in part by Medicare or a state health program. They got all kinds of stuff going on. So yeah, we also have, as a result of the 21st Century Cures Act, information blocking. They recently released some information on what happens to an entity who has been engaged in conduct constituting to information blocking. Yeah, and a health IT developer of certified health IT and health information exchanges and networks commit information blocking when they engage in a practice that is likely to interfere with, prevent, or materially discourage the access, exchange, or use of electronic health information, and they know or should know the practice is likely to interfere with, prevent, or materially discourage the access, exchange, or use of HI. A healthcare provider commits information blocking when the provider engages in a practice that is likely to interfere with, prevent, or materially discourage the access, exchange, or use of EHI, and the provider knows that the practice is unreasonable and is likely to interfere with, prevent, or materially discourage the access, exchange, or use of the EHI. So they recently, the Office of the National Coordinator of Health Information Technology released some information in there. A health IT developer of certified health IT health information exchange or network that engages in information blocking may be subject to CMPs of up to $1 million per violation. This was the final rule that they've issued on this. And did they say the provider? Oh, a healthcare provider may be subject to appropriate disincentives as set forth by HHS in a few. They just recently dropped that. So that's what recently came out, the disincentives. Individuals and entities that meet the definition of healthcare provider under ONC's regulations should be mindful that they may be subject to CMPs if they meet the definition of health IT developer of certified health IT or health information exchanges and networks under the ONC's regulations. The exclusion authorities, they decide and determine mandatory exclusions, permissive exclusions, and I thought it was another one. Maybe not. Many providers and their staff employ excluded individuals because they incorrectly believe it is permissible. For example, because an employee obtains a new healthcare license or has received permission from a state agency to practice, has an administrative role, cannot bill separately or cannot separately bill, and that is not true. So, and they recently updated the exclusion list this month. So if you need to go out there and check it for the LEIE monthly, they do it every month. You can check that out. So that's section 2. A lot of information. Well, this again was a joy and a pleasure for me to serve you today and bring you information that you need to know. Thank you again for joining, and remember, be safe, be kind, and don't wish for it, work for it. Until next time, take care.